Anthony Show continues.
Why ask us? Why ask us then? What happened, Sal?
I came back and the sweeper hit. I was literally running out of time. No one was in there. I literally couldn't run fast enough.
Sal comes in. You're back in 30 seconds. You want to stretch a little bit?
Yeah, we stretch sometimes.
Jimmy's eating and stuff like that a little bit.
And we discuss things and whatever. There's times where we need to stretch a little bit.
So Sal goes like a minute and a half, whatever.
Yeah, he goes, you want to stretch? I go, yeah, I guess. Go like a minute. Give us one more minute.
And then
10 seconds later,
10 seconds later, we're back. So
I'm
what
sorry,
happened?
but no, Eric wasn't here. Sam wasn't there. I couldn't communicate to you guys.
Sam and Eric's problem.
Sam,
okay.
He's blaming you.
Sam and Eric.
And where is Eric?
He's taking a shit or eating. He's one of the two.
But he just leaves his post?
Yes.
Oh, man.
What would have happened if you didn't step in, Sal?
There would have been dead air.
Oh, you should let it happen.
Yeah. No, I don't want to do that to you guys.
Well, no, it's doing it to Iraq.
An improvement to the listeners.
Sal still
let it happen.
Yeah, Sal doesn't understand still.
It'd be helpful to you guys.
Of course it would be. It would give us 20 minutes of radio if all of a sudden, like, we look and, Iraq's not at his post.
I guess that would have been pretty good, yeah.
Oh, man, that would have been great.
It would have been amazing.
He said, he goes, you guys want filler? And you go, yeah, a minute. And he goes, all right. You're back.
That's pretty much what
Sam,
happened.
you weren't in there. I couldn't communicate to anybody.
Sam, you weren't in there.
Yeah, but you communicated directly with them. You actually
did. You did communicate
me.
And then
by the time middleman, if you just spoke to us.
By the time I got back to here, the sweeper hit, and there was nothing I could do about stretching. That's exactly what happened.
So the sweeper hits on its own?
The sweeper hit, and there's nothing we could do about it.
There was nothing we could do.
Does the sweeper hit on its own?
If the filler ends, it's going to hit automatically.
It's on autopilot. It's like that fucking. It's like the
we're learning
the plane crash.
Yeah, we're learning we don't need Iraq today.
It was on autopilot, and that's what happened.
So Iraq's shitting, and he didn't tell anyone to go in there.
No, he said I'm going to go pee. I said okay. And he's been gone for, I have no idea how long. He's been gone for 5 minutes.
Unless you're asked to fill in Iraq's position, you never fill in Iraq's position. Like, why would you just take the lead like that?
Right.
Just let it, okay.
Let the chips fall where they may.
What's that?
Oh, no, Chip is really working his catchphrase now. Well, you know what? Come on. We got Judge Alex out there. We can't make him wait. He's a busy guy. Should bring him in, huh?
Yeah.
I think he goes... He's all over the place these days. Look at him taking calls. He's on TV shows.
Judge Alex.
Judge Alex, take a seat there.
What's going on, brother? Welcome to the show.
Welcome.
Yeah.
Appreciate it.
With the mic, however you need it. I don't know.
He knows how to work the mic.
Of course he does. Yeah.
How do you say? We were debating how to say your last name. I say Ferrer.
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 I think I might have won that one.
Ferrer.
Got to pronounce that E, right,
But it
Alex?
wasn't Jose Ferrer, was it? Or
Yeah. Mel Ferrer, Jose Ferrer, yeah.
Why am I? I was actually hoping that he would. Oh no, Jim, you're right.
No one ever says that.
No, never. So.
Depending on how long I'm here, that might happen.
Yeah.
When's your TV show on, sir?
Well, it used to be on Fox 5 at 2 p.m. It's syndicated, so it's on different times and different stations across the country, and they constantly move it, so I'm not really...
What's the big ones you do? Landlord disputes or what?
No. Well, yeah, I mean, actually, everything is small claims. Everything is.
I love small claims. We got sued recently, and I kind of enjoyed just sitting there waiting for our turn, because there was some weird shit going down that day.
It is fun to watch.
It was a lot of
something to watch.
The cases come up, but...
And it's over nonsense. It's over like a few bucks. Why bother?
Well, I mean, I think a lot of times it's about the principle of the thing. I mean, I had a woman who sued for $46. And she spent $70 in legal fee in clerk fees. And she would be entitled to them back if she asked for them, but she never even asked for them. She didn't care about the $70.
She just wanted to say, I was right.
She wanted somebody to tell this person that they were wrong. Yeah. And, a lot of them are very personal. I mean, the public doesn't care about IBM and Microsoft being in some antitrust suit or something like that. What they care about is, like, I had a woman who, her friend came to her and said, don't spend $2,000 on a photographer for your wedding. I could do it for half of that. I'll do it for $1,000. So she said, okay. She paid her $1,000, and then she's getting out of the limo, pulling her train of her dress behind her, and looks up to see her friend snapping pictures of her with those little yellow disposable cameras you pull out of the dollar cameras from the bin, the discount bin. And she had a bag hanging from her arm with about 12 more of them.
And that's how she was going to photograph the wedding.
That was a $1,000 photographer there.
Wow.
Sometimes you get what you pay for, though. Yeah, you're getting screwed.
It's amazing the interest people have in the legal system, though. Like I guess it started with the People's Court, and then went to who was after that, like Judge Judy, but people are, or Joe Brown, and people are fascinated. But I think it's what prevents people from hitting each other is the fact they can go to court. It's a way of.
Well, I mean that is why we have court. So we resolve the disputes in some civilized manner,
pounding each other,
as opposed to dueling.
Yeah. Whenever we have these big cases, like of course the Zimmerman trial going on right now, people seem to want to get involved. You know, they want to watch the trial, but they don't seem to want to get all the facts.
No.
I've seen, especially with the Casey Anthony trial, of course, and this trial, people have very strong opinions based a lot on emotion, not many facts of the case and education on the judicial system.
It's not limited to court system. I mean, with social media, somebody says something and everybody accepts it as true, and then they repeat it, and then they amplify it, and it's like a global game of telephone, and it completely changes, and it's gospel, all the way through.
There have been some things that were brought up that were just plain lies, rumor. Things that were thought to be fact at the beginning of the investigation, and now as it's evidence in court being presented, it was found that was completely false, yet people are still repeating it, and you can't tell them different.
Right. Well, I think originally George Zimmerman, when he called the police, said that when he was describing Trayvon, he said it's somewhere between 5'11", 6'2".
Right.
Well, forever Trayvon was 6'2".
6'2", and then we find out he was 5'11". Yeah.
I mean, he nailed the height pretty well.
He actually did. Yeah. What's the one thing that you've noticed in social media? Because I see on Twitter a lot with this case that people just plain have wrong. The one that just keeps coming up that you're like, my God, how many times?
I mean, everybody. If you depending on which camp you're in, those they're the extremists on the George Zimmerman side that are like, absolutely did nothing wrong. There's no way that he could have done anything that was improper in this case when they don't really know. Nobody knows what happened at the time of the confrontation.
Sure.
I mean, we have George's version, but obviously George has a reason to be biased on that. And then you've got the other side, which is absolutely no self-defense. I don't care how many times you beat it on the concrete. It doesn't matter. He approached him. He got out of the car. He should never have done that. And he's a racist.
Right.
And then you have the ones in the middle who are really, I have friends who seesaw back and forth. They hear this piece of evidence. They hear that piece of evidence. They're going back and forth.
The smarter ones who are weighing it as it happens.
Right. Well, they're not trying to justify a position, which is what the others are doing. The others have made up their mind, and whatever evidence comes in, if it's good for them, that was great, credible evidence of court. And if it wasn't good for them, that guy was clearly lying.
So they're basically asses.
And they will.
Jimmy's still trying to get me to say I agree with you.
Yes.
So I think that the racist part is the part that I think a lot of people have gotten wrong. I mean, I don't know George Zimmerman. Maybe he is a raging racist, but so far the evidence seems to be, and even the detective got on the stand and said, listen, when I found out that this guy was mentoring African-American children, I realized, come on, this guy isn't a racist. I mean, and he went in front of the county commission at one point about a cop's son who beat up a black homeless man.
Right.
And berated the police department about it, and then went out and tried to fundraise for this black homeless person. Those are not the typical things that racists do.
Unless you're the most clever racist ever, and you're padding your reputation before you do this.
And I think that's a problem with the claim of racist. It spans somebody who is KKK to somebody whose neighborhood has been burglarized by just a stream of African-American individuals, and so therefore the next time he sees an African-American individual, he must be racially profiling.
Right.
And it's a very broad spectrum.
It really is. Yeah, there's no volume knob on it. It's one extreme to the other.
Now, don't get me wrong. I don't have any problem with the fact that race was injected into this case at the outset. I think to ignore the possibility when you have a white male who calls in about a black male who wasn't doing anything, it's right to say, well, I wonder if this was racially motivated, because we do live in a racist society, and there is a lot of racism. But when you don't find evidence of it, then it's time to say, okay, maybe I was wrong.
Move along.
Some people will never say they were wrong when it comes to that claim.
Do you know?
And some people will never see racism even when it exists.
Why did the press? I mean, we all know why, but they go with, like, he's Spanish and he's white. But they just refuse to go with the other angle. The white angle is just so much juicier. It seems.
By the way, what am I? I've gotten this question a million times, and I used to think that white was a race and Hispanic was an ethnicity. But I think somewhere along the line that changed, and I didn't really get the memo on it because people tell me, like, you're not white. And we have black Cubans and white Cubans. I'm Cuban. So I'm not really sure. I guess it doesn't matter now.
What is it? What do you check in the little box when you have to check?
When they give me a choice for Hispanic, I check Hispanic.
Okay.
But when you typically, I'm thinking from my police days. In my police days, if you were describing somebody, it was you didn't. If you were black, you were black. If you were white, you were white. And that was for identification purposes, because if the other police officer needed to try to find him, we're looking for a white male or we're looking for a black male. You can be Hispanic and be noticeably Hispanic. I don't think I fall into that category, although some people confuse me for Middle Eastern or I don't know what. But
Maybe
I never
Jewish.
really
A little Jewish.
A little Jewish. I get okay. Well, I do know the prayer of the bread and the prayer of the wine because
there you go.
I grew up Catholic, but I'm hedging my bets in case my parents are wrong. But anyway, so this is a very high tension case. This is not like Casey Anthony, because in Casey Anthony everybody was pretty much united behind the fact that she killed her daughter.
Now that's an interesting case and I followed that one like I'm following this one, and as I watched it very closely, I did not see the prosecution present a case where she could be convicted.
Wow, you would have fit right in on that jury.
I did, yeah, right. I just didn't see it.
I don't know what expectation the jury had. That was a circumstantial evidence case. This is a circumstantial evidence case. But that was a circumstantial evidence case. But it was a powerful circumstantial evidence case. I mean, you had a 2-year-old girl, 2 or 3, I don't remember now, 3 I think, approaching her 3rd birthday. 3-year-old girl whose body is found in 2 bags in the woods with duct tape that was clearly positioned over her mouth and nose before her body decomposed because it was still attached to the hair on the side of her head. The one strand of duct tape would have been enough to cover her nose and mouth. She had 2 strands overlapping each other and one diagonal across the face. Mom never reports her missing, ever. Would never have reported her missing if grandmother hadn't called the police. Okay, the day she disappears, that we know she disappears, Mom goes out to see her boyfriend. They start whooping it up. She enters these hot body contests. She goes get tattoos and stuff like this. Okay, Mom's car smells like a decomposing human body. Okay. Alerted on to by cadaver dogs and the guy called Dr. Death, who's Dr. Voss, who runs the body farm in Tennessee and knows more about decomposing human bodies, the smell of it, the composition of it, than anybody in the world. Okay. And then when she is confronted with this, Mom lies. Mom makes up stories about the nanny took her from me at the park. The nanny took her to take care of her and then didn't give her back to me. I didn't call the police because I was doing this manhunt on my own. When you add all these things up, it's like, no, you killed her. Now it's a circumstantial evidence case, but a lot of cases are circumstantial evidence case. So I think it was a very powerful case. And then Mother's response, her theory, makes no sense, because if you take the whole drowning theory, what you're saying is, now remember, Casey Anthony's father and mother were like doting grandparents over Kaylee. I mean, they built her a little playground in the backyard. There was all the evidence was they absolutely adored her. So what Jose Baez was asking this jury to believe, which I guess apparently they did, was that this grandfather, because the story was Casey wakes up and she goes out and father says, "Where's Kaylee?" And they go looking for her body, looking for her. And the father finds her body in the pool and says, "Look what you did. You're going to go to prison for the rest of your life for child neglect." Okay, if you believe that, then that means Dad, who is a former police officer and knows, like I know, that tragic accidents like this happen all the time, and nobody's going to prison. It's sad. It's tragic. It happens. Nonetheless, he takes the body of his granddaughter, who he loves so much, and throws it out into the woods to be basically eaten up by animals to protect his daughter, Casey, who's not going to go to prison, but because he loves her so much. Yet, when she gets charged wrongfully with the murder of her child, and he knows she didn't murder the child, she drowned in the pool, it's an accident, he doesn't come forward and say, no, it's an accident, we should have called, and all this stuff. He just lets her sit in jail for 3 years. She never raises this defense until the day of opening statement. She sat in jail for 3 years when she could have walked, for the drowning. And he lets her sit there and go through a trial where she might be put in the death chamber.
And also the duct tape, too. Why was the duct tape there if she drowned? Who duct tapes a dead body?
To make it look like a murder. People try to make murders look like accidents. They don't try to make accidents look like murders. So
why weren't you the prosecutor in this?
Yeah,
that was
summed that up pretty nicely.
Pretty good summation.
Yeah. That was my closing argument.
That was your closing argument right there.
They couldn't prove that she drowned, right?
No, they couldn't.
Yeah, of course.
They
didn't really have a cause of death.
What the fuck was the jury listening?
Well, did they overcharge her with was the problem they could not convict her of murder, or it could have been an accidental death? Or
they got instructed on manslaughter.
Oh, they did.
Yeah. What happened was people said, well, you shouldn't have gone for the death penalty. Well, the jury had options. They didn't have to go with murder 1. They could have gone with murder 2. They could have gone with manslaughter. They just weren't. We see it all the time. As a judge, I see jurors who do not want to convict. I had a woman who was shot 5 times in the back by her husband. Witnesses saw it. She lived, mind you. I would have been stuck with a pencil and I would have died of lead poisoning. She gets shot 5 times in the back, and she lives and comes to testify. And the witnesses testified that he put on no defense. His lawyer, basically in closing, got up and said, my client didn't shoot her. Her new boyfriend shot her. Now, first of all, there was no evidence there was a new boyfriend. He had been beating her their whole marriage, and she said, I had enough, and she moved out. 2 weeks later, he says, come on, let's talk about this. So she met him to talk about it, and he shot her 5 times in the back.
Wow.
So there was no evidence there was a boyfriend, let alone that the boyfriend shot her, and the jury walked her. And the prosecutor went out to the jurors outside and said, can you please tell me why you found him not guilty? And they said, which is very interesting because it's similar to the jurors in the Casey Anthony case, they said, we thought there was something else going on behind the scenes that we didn't get to see. Really? I mean, if that isn't rank speculation, and the jurors in the Casey Anthony case said, we thought George was involved in some way. Never mind the fact that there was no evidence of George's involvement. There are some jurors who, one, don't have it in them to say guilty and look for any excuse to say not guilty. And there are 2, jurors see crime shows on television, and crime shows never end the way you think they will. Jimmy, it's Jimmy, it's Jimmy. No, it's Opie. So they sit there and they look like, okay, I see all the evidence you've given me here. Yeah, it sure looks like it's Jimmy, but I can solve this. I know I can figure it out.
They don't believe that 1 + 1 is 2 because the crime shows are always telling them something different.
Right. Well, they're looking for the twist.
So you see the jury get it wrong a lot, then, huh?
It happens.
What's the percentage?
I don't know. But I mean, it shouldn't happen, but it happens.
Yeah.
Yeah,
way more than it should.
The thing I saw with the Casey Anthony thing was I didn't have a story. I didn't have the prosecution presenting me with a viable timeline of what happened and all right, she did this, here's how the kid died and when the kid died and here's where it was a little ramshackle, and that's why I was like, I don't think they got it here.
Well, but there's when you get instructed on the law, one of the instructions is not there has to be a timeline. One of the instructions is not you have to know the motive. You don't have to know the motive. She could kill her daughter because she wants to be free. She could kill her daughter because she's angry at her mom. She can kill her daughter for a lot of reasons. And the prosecution can never prove motive unless the defendant gives it to her by telling somebody or they can piece it together by other evidence, because they can't crawl into the defendant's mind, and the defendant has a Fifth Amendment right to remain silent, so they can't force the defendant to tell them why they did something.
Why they would do something or not.
That's why it's not an element of the crime. All you have to prove is that she murdered her daughter beyond a reasonable doubt. So we have, their defense made a lot about, they don't have cause of death. They don't have the cause of death. They have the manner of death because the medical examiner testified that it was a homicide. But they didn't have cause. Was she strangled? Was she shot? Was she poisoned? They don't have that. But you don't need that. I mean, there are people who are prosecuted when you don't even find the body.
Right.
If you don't find the body, how are you going to prove cause of death?
Yeah,
you know. So the question isn't that. The question is, after you've looked at all the evidence, has the state proven that this person killed this person?
But at least, even if you don't have a body, something like before they found Lacey Peterson's body,
right? They were prosecuting before.
Yeah, they were, exactly, and they had some type of timeline where it's like, okay, look, she's here this day. He goes fishing. She disappears. Like, it makes more sense than this very spread out. And I know you're saying they don't have a timeline.
They did have a timeline in the sense that it was Father's Day. Kaylee and Casey were together with George, the father. And then that was the last time they were seen together. And then they had the timeline of her living with her boyfriend the next day, telling everybody, oh, Casey is with her nanny or Casey's with her grandma. You know, she'd tell the boyfriend Casey's with grandma, and she'd tell the grandma Casey's with the nanny.
I understand what you're saying there.
That timeline.
Here's what I'm thinking. The jurors,
you want a boat and the ocean involved.
The thing is, you can imagine. A juror can sit there and imagine, all right, there is Scott Peterson. He's in the boat. We don't know anything yet, but he rented a boat. He went fishing. He took the boat out. They could picture that scene. The body's in there. He's tossing it over.
Right.
You can know that from what happened. With the Casey Anthony thing, there was nothing like, I'm picturing her drowning the kid. I'm picturing her strangling the child. There was not that moment that put in the juror's mind her killing the child. And I think that's very important.
Well, that's true of most circumstantial evidence cases. You know, it's ideal. It's ideal if you have somebody who says, "I saw it," and then you're just evaluating their credibility. Well, and then that's direct evidence. And then when you're piecing evidence together, you're building inferences. You know, this inference goes on this inference, and then, you know, if you build it strong enough, you overcome reasonable doubt. You can never overcome all doubt.
All doubt, right.
No, because the only way to overcome all doubt is for the jurors to have seen it themselves.
And a confession.
And even then, because it comes in and goes, look, they promised me if I confess, or they beat me, or they turned the recorder off and they threatened me, or whatever. So the only way you can overcome all doubt is if you saw it yourself. And if you saw it yourself, you couldn't be a juror because you're a witness. So, you know, the standard is reasonable doubt.
And didn't in the Peterson case, wasn't there a strand of hair found in the boat, and he lied and said that she had never been in the boat, and that was one of the things that got him convicted, was a strand of her hair found in that boat? And I
think it was on a block that was in the boat, or some cement.
Oh, it was something in the boat. Okay.
Yeah, there was like cement dust and red.
With her shoes in it.
Yeah. Well, but I want to get to the Zimmerman case because that's the one that is huge right now. What do you think? Defense, prosecution, who do you think's scoring more points here? Where do you see it going?
First of all, let's start about this as a tragic case. You have an unarmed 17-year-old who's killed, and that is horrible. And we in the justice system see cases all the time where they are tragic, and in a lot of those cases, unfortunately, the prosecution can't make a case. They just can't. You know, the prosecutors get whatever evidence exists. They can't fabricate it. They can't make it. They can't improve it. They're stuck with the witnesses they get. Some of the witnesses are Rachel Jean Tell, the girl who was on the phone with Trayvon, and some of the witnesses are Dr. DeMaio, who testified yesterday. You have a whole range of witnesses, and the prosecution is married to them. Whatever they are, they are. However they behave, they behave. So that being said, this is a case that the prosecution has had difficulty with it from the beginning. At first, I was really tough on the prosecution. I still am in some respects because some of the things they've done. But it's, I think, a case where it's become clear to me that the reason this case wasn't brought originally was not because of racial bias. It was because there simply isn't enough evidence.
You thought that the police on scene, when they initially investigated, just didn't have enough?
Well, first of all, let's start with the police on scene. A lot of people say, well, he should have been arrested immediately. Well, no, because Florida does have a stand your ground law, which does provide immunity from prosecution and things like that if certain elements are satisfied. Well, this exact scenario happened in Miami, where it was an African-American male who shot actually his friends, 3 white males, and killed them. And when the police arrived, he said self-defense. They were attacking me. I had to stand my ground. And the police didn't, like in Zimmerman case, did not have anything to dispute it. So they did not arrest him. And then weeks or maybe months later, they pieced together through, like in the Zimmerman case, they went out and they canvassed and all this stuff. They pieced together evidence that he was lying about acting in self-defense, and they went back and they arrested him. But that's another scenario that shows, this is the police have to worry about civil lawsuits.
Sure.
If they arrest somebody without probable cause, then they're subject to being sued. If they arrest them with probable cause and it turns out the person's not guilty, it's okay. You had probable cause. But if the person is presenting a defense and you have nothing to dispute it, you don't have probable cause to arrest them.
Right.
So originally that whole outcry about the fact that it was racially motivated, while certainly something that should be looked into, because like I said, I have no problem with people looking into the racial motivations. That being said, it appears more and more that this was not prosecuted for the right reason, which is, unfortunately, as much as you'd like to have the evidence, if you don't, then as a prosecutor, you have an ethical obligation not to bring a case that you cannot prove.
Do you think that the guys you're talking about in Miami who were shot, the cops went out, they found some additional evidence, and they arrested him? And in this case, they arrested him later, but do you think that was more due to public pressure or the fact that they found something that made them doubt his story?
I'm suspecting that it was more due to public pressure. There are inconsistencies in George Zimmerman's testimony. There are clear inconsistencies. There are things I flat out don't believe him on.
What don't you believe him on?
Yeah.
Well, I don't believe he went out to look for a street sign. I believe he was following Trayvon to find out where he was going. I think that I believe that he was fed up with the fact that these burglars keep getting away. Our neighborhood keeps getting broken into. We started a neighborhood watch. We call the police when we see somebody who seems out of place. And when the police get here, the person's already disappeared.
Right.
So this time I'm going to watch him and see where he goes. So when the police come, I can say he's right behind that bush.
There he is.
Or you're right. And I think that's what happened is he went out of the car and the dispatcher told him, you don't need to do that. That's not a police order. I mean, I deal with the things that are emotional to the public. They say, well, he shouldn't have been following them. Well, you can follow anybody you want.
That's one of the biggest misconceptions that people have.
If I see somebody leaving your house and come out through the window, and I call the police and I say, hey, my
There's
friend,
a 13-year-old girl.
Right. My friend Anthony State from last night just crawled out the window, and so I follow this guy, and I'm calling 911, and they're sending units or whatever. They're going to tell me not to follow him.
Sure.
Because they don't. If this guy is a serious criminal, they don't want me to get killed.
It's for your safety, for the most part,
or I could make a mistake and misinterpret things, and the person might not be up to anything, and I could end up killing him, like may have happened in this case. Police officers are trained in shoot, don't shoot scenarios, and we make mistakes. And so imagine civilians who aren't trained in shoot, don't shoot scenarios. So, also, they don't want to be liable, and that's what this dispatcher testified to in this case. He said, look, we tell them not to follow because if we tell them go ahead and follow and they get injured, we get sued. So we tell them not to follow, and if they follow, they follow, but it's on them. So he goes ahead and follows them, and I think he makes up the story later because he thinks, oh, my God, they told me not to follow, and he makes up the story about going to see a street sign.
Right.
The reality is, he didn't commit any crime by following.
By following, right.
There's no evidence that he went running up to Trayvon swinging a bat or even swinging a fist. There's no evidence that he was the aggressor in that sense. Now, people want to say, well, he was the aggressor because he followed. That doesn't make you an aggressor.
It doesn't make you an aggressor.
I could walk up to somebody in the street and say, what are you doing in my neighborhood? And they could tell me to go pound sand. But I haven't committed a crime, and neither have they.
Until someone gets hit.
Now, somebody throws a punch. Now you've got a crime, and so I disagree with him on that. So as far as the case is concerned, the prosecution, I believe, does not. Well, first of all, they haven't proven the second-degree murder. They just have
not at all.
Now, that's not to say a jury won't convict of second, because just like they can acquit Casey Anthony, they can acquit him. It's just a question of whether it would survive on appeal, and I don't think it would survive on appeal. The remaining issues are manslaughter, which is just as bad as second-degree murder for him, because manslaughter in Florida is a second-degree felony. The maximum for a second-degree murder is life. The maximum for manslaughter in Florida is 15 years, but because you use a firearm, it goes up one level and becomes a 30-year felony.
Right.
So maximum is 30. Okay.
I was looking at manslaughter, the manslaughter statutes in Florida, with the justification. It doesn't even seem like manslaughter fits this, based on what I've seen in
Which one are you looking
at? Manslaughter. Manslaughter 1.
well, there are different versions of manslaughter in Florida. There's what's called manslaughter by culpable negligence, which is a culpable negligence is a greater level of negligence. If you are negligent and you kill somebody, you don't get criminally prosecuted, because negligence is like I'm driving down the street and I look down at the radio to change the station, and I accidentally blow a red light. Mm-hmm. If I T-bone a car and somebody dies, I'm not going to get prosecuted. I'm going to get sued, but I won't get prosecuted because I didn't have a criminal state of mind. And I can tell you the different degrees of murder if it clarifies it, but basically that's negligence. Culpable negligence is a higher standard of negligence. For example, DUI. That's why they get prosecuted. They got behind the wheel of a car drunk. They didn't intend to hurt anybody. They weren't doing any act out of ill will, hatred, or spite. They just did something that was so negligent. If I put a target in a lake, in the middle of the lake behind a house, and I start shooting at it and really don't even think about the fact there are other houses on the other side.
Right.
I don't have a criminal intent. I don't intend to shoot anybody. I'm not angry at anybody, but it was such a gross negligence that the bullet going through the target and killing somebody subjects me to manslaughter. So that's culpable negligence manslaughter.
Do you think that does not
apply in this case?
I don't think that applies either, right?
I mean, I guess an argument could have been made had they charged it this way. An argument could have been made that, getting out and following a 17-year-old boy in the dark, in the rain, armed with a gun, culpable negligence. I don't think that would do it, but at least there are things the prosecution is arguing in this case that are worse than that.
Yeah, and there's no argument here that he didn't pull the gun out. He meant to pull the gun out and shoot him.
This is an intentional act.
He wasn't like, I meant to shoot the bird over here, and I
accidentally hit him.
He meant to shoot him.
Right. But there's another negligence, which is basically, another manslaughter, which is basically an unjustifiable killing. Mm-hmm. So my look at this case is, if the jury rejects self-defense, if they feel that he shot Trayvon without justification because it was not a reasonable fear of death or serious bodily injury, then the default is manslaughter.
Okay, right.
So that's the one that he could. It really all hinges on self-defense.
Now, personally, do you, with the evidence you've seen so far, before the closing arguments and whatnot, what do you think? Do you think he falls into that? Do you think he proved? Do you think his side showed enough to say to the jurors that this was self-defense?
The only way I can answer that is yes and no, because it's up to the jury to decide what's reasonable. What's reasonable to me or to you or anybody else doesn't matter.
From what you've seen, does it seem reasonable that he was in fear of his life?
I would say that from what I've seen, a jury could certainly say, yes, he did he fear. There's two prongs. One, was he in fear of either death or serious bodily injury? And or serious bodily injury is an important part, because you don't have to fear you're going to die, but you can fear that you're going to suffer serious bodily injury. And if the jury believes him that Trayvon's on top of him, punching at him, hitting his head on the concrete, and Dr. DeMaio was very helpful in that for the defense yesterday, because he said, look, those little cuts on the back of the head are not serious, but they're indicators of a serious strike against the pavement or a hard surface that could cause, and he described what could happen. You could have brain bleeding, you could have you could get a cracked skull. In fact, he said the police should have taken him to the ER, because had he died at the police station, the department would have been sued and they would have lost. Yeah. Because you knew he had a head injury. Head injuries are very dangerous, and you didn't take him to get checked out. He said, and his words were, he had two phrases. One was, with a head injury like that, you take him to the ER, no questions asked. Well, that puts it in the context for the jury. The second thing he said was, concrete doesn't yield. If you strike your head against concrete, your head yields. That was an interesting quote.
That's a good one, too, yeah.
He was a great witness, right?
He was a fantastic
really believable.
And don't forget, we also learned you could live without your heart for 15 seconds.
Yeah.
That creeped me out.
I wouldn't recommend proving that.
Yeah. Wow. I thought it was many years longer by this room.
They said even if it's pulled out of your chest, you will live for another 10 or 15 seconds.
Right.
Talk and walk. Oh, my God.
And he said that he had a case where a guy took a shotgun blast to the heart, and his heart was completely shredded. Wow. And he ran, I don't remember if he said 65 feet or 65 yards, but he said before collapsing.
Wow, man, that's something.
I'll guess feet.
Yeah. God, thank feet.
Do you believe, by the way, you talk about what's believable, what's not believable. Do you believe, I don't buy Zimmerman's "you're going to die tonight," and the way he said he saw him reaching for the, I think he's saying what he thinks is legally getting him off.
First of all, a lot's been said about Trayvon's fighting history and stuff like that. Could he have said that? Yeah. Is it likely in my experience? No, in my experience, the people who say things like that are not 17-year-olds who've never been to jail. They're guys who've been to prison 3 times for armed robbery. You know, they say things like that. The going for the gun, I really don't buy that either. But he doesn't need that. I mean, it's an example of trying to strengthen his self-defense claim. I don't believe it because his gun was on an interior holster against his body, near the back, in the dark. I just don't see Trayvon going for it. I think what happened is Trayvon was punching him, was hitting him, and I don't know why. Maybe Trayvon is cocky. Maybe Trayvon just likes to fight. Maybe Trayvon was scared. Maybe George Zimmerman walked up to him with his gun in his hand to kind of say, like, hey, you know what, don't mess with me because I'm armed, because he doesn't know if this guy's a burglar or not. So he may have walked up with the gun in his hand, or he may have pulled the jacket back and flashed it. And if he had the gun in his hand, I could very well see Trayvon going, this crazy cracker is going to kill me. And jump him to try to get the gun away.
Wouldn't that remove self-defense completely, though? Doesn't that count as upping the aggression if your gun is out?
Yeah,
yes.
But you have to prove it.
Now, don't get me wrong. That is complete speculation on my part. I'm just talking about reasons why Trayvon might jump him.
But people absolutely hear things like that and believe, just because it can be speculated, that has to be something that needs to be considered in this case.
Right now, I'm sure that on my Twitter, people are posting, Judge Alex says that Zimmerman pulled his gun and pointed it at Trayvon. I know.
Have fun with that.
So in any event, so there are a lot of things that could have happened, and this is where I think the public misses the point, and I can understand why, because they're acting from emotion, and those of us who work in the judicial system are used to not acting from emotion, but acting from an analysis of what the elements of the crime are in the law. And then, of course, that makes you seem like you're really cold-hearted and don't care, but it doesn't really matter what could have happened. What matters is what the police can prove happened, because the police are trying to take away somebody's liberty, and in order to do that, they have to prove the elements of a crime. And the elements of a crime are very specific. The elements of a crime are like the ingredients for a cake. If you leave out one, you don't have the cake. And if you order a lemon meringue cake from me and I leave out the lemon, you did not.
Oh, that's a crime in itself.
You didn't get what you ordered, and that is the way the elements of a crime are looked at. If you have to prove ill will, hatred, spite, and evil intent, and you do not have evidence of that, you do not have second-degree murder.
Right.
No matter how much people at home go like, "What are you talking about? He killed him. It should be something more than whatever."
And that's what you get in a lot of these tweets from people.
And it's understandable because it is a horrible crime. Look, my mother lost 2 children, but both of my brothers are dead. I know what it's like for a parent to lose a child. It is a hole that is never completely filled, and it is a gaping wound for a very long time. So I sympathize with the family completely. But we're talking about what is legal in the justice system.
Right.
We have a justice system because, you remember in the Wild West days, people would go with the torches and pitchforks over to the
put a rope over a branch.
Exactly. And go and pull people out. And, we're not waiting for the justice system. So for that reason, we have a justice system that is not always going to give the result you want, i.e. Casey Anthony. But it doesn't promise you anything. It doesn't guarantee you a guilty of people you think are guilty or a not guilty of people you think are not guilty. What it guarantees you is that the prosecution and the defense will get a fair opportunity, each of them, to present their evidence to the people they picked. That they get a panel. It's a random panel. They pick the people they want from that random panel, and they get to present their case to those people, not to us. We haven't been screened for biases or prejudices.
Sure.
Those people have. So they present it to them and let the chips fall where they may. They say guilty or not guilty. It's a process that you're guaranteed, not a result.
Now, the thing is, with a self-defense case like this, especially when the police initially deemed this self-defense, why should someone have to take the chance on a jury when this shouldn't have been brought in the first place?
Well, that's the reason.
And I hear a lot of people say, well, we need justice for Trayvon. We need this should be looked at. Not all things should have to go to trial.
That is the point I was making before, that the prosecution has an ethical obligation not to bring a case they can't prove.
Right.
And the reason for that is, if you can't prove it, then we have the beyond a reasonable doubt standard for a reason, and that is because we don't want to convict people who are innocent. Innocent either because they were justified, like, it's hard to say innocent and get people to get it when you've got a situation like this. But, the example I give when I'm talking to people sometimes is if you get up in the middle of the night, you hear a noise, you grab a gun, and you shoot somebody who's coming through your window at home, and it turns out that your daughter called her boyfriend and said, I left the window open, come over. You just killed a 16-year-old kid who was unarmed and wasn't doing anything. But you're still not guilty. I mean, you had a reasonable perception under the circumstances, okay? Yeah. So that the jury, the reason for the reasonable doubt standard is, beyond a reasonable doubt, is to make sure that innocent people, whether it's this case or any other case, do not go to prison. We bend over backwards to make sure that doesn't happen. So incumbent upon that is that the prosecution not bring a case that they can't prove beyond every reasonable doubt, because there is the risk, especially in emotional cases like this, that a jury will disregard the reasonable doubt standard and convict on emotion. Right. If they do, there are safeguards. The court can set aside a conviction. They can't set aside an acquittal, but they can set aside a conviction if it's against the manifest weight of the evidence. The appeals court can throw it out, but you can't bank on that. Right. You can have an innocent person. We've seen innocent people who lately have been, exonerated after many, many years. I mean, how'd you like to give up 20 years of your life to find out, oh, yeah, we were wrong. Sorry. Yeah, sorry about that. Here's a couple $100,000 that'll make up for 20 years of your life.
I'm sorry to interrupt. Do you think they'll allow the pictures into evidence from the cell phone and the information about...
I don't think so. Texts. I don't think so, and legally it is not supposed to come in. It's certainly not supposed to come in that way. The prosecution, if the defense, the character evidence of a witness rarely comes into evidence, but when it does come into evidence, there are two different types. One is it's an element of the crime. Those are rare. The character of the victim is an element of the crime. The other is that it supports a defense or a claim in the case. This is where that would go to. In other words, text messages of Trayvon that he's fighting and that he said, I didn't hurt this guy so much, I only broke his nose, certainly support George Zimmerman's claim that this is what happened. He attacked me and he was beating on me and all this stuff. The problem is that legally, you're not allowed to prove a victim's character by specific acts of conduct, like he fought before. And the reason for that is because everybody's done something in their past. So you can always bring up, a year, Jimmy's accused of beating me up, and I can bring up that a year ago he got in a bar fight. And the jury goes, what a coincidence. You're accused of beating him up, and you were in a bar fight last. Well, everybody's done something in their past.
When you're claiming self-defense, doesn't the victim also become the perpetrator in that essence?
In every situation like this, the person claims self-defense. If they can't claim that it wasn't them, right? Because the first defense is it wasn't me. It's the Shaggy defense, right? If they can't claim that, then they claim, it was me, but I had to do it. Right. Okay. So you can put in evidence of Jimmy's character for violence, but you have to do it by reputation. And the reason is because reputation is broader. It's not a specific act or whatever, or two acts. Okay. He has a reputation for violence. And to do that, you call friends who know, or people who know his reputation. May not be friends, but people who know his reputation and say, yes, I've known Jimmy and I've known him for years. And in the community, he has a reputation that he's a violent individual.
I would have thought just the opposite, by the way. I would have thought that's all like hearsay and the specific acts are more provable. I would have thought totally the opposite.
Yeah, you would, except that in a weighing analysis, the specific acts are incidents that don't necessarily speak to your character. Anybody can be a good person and fly off the handle one day. Right. One day you're like, kill you, son of a bitch. Yeah, yeah. As opposed to this person is a violent person and all this stuff. So I don't think it's coming in. Yeah. Honestly, I don't know what she'll do because I've disagreed with some of her rulings down the line here. So I don't think it's coming in, but
has she leaned more for the prosecution or the defense as far as her decisions go?
Well, she definitely hasn't leaned for the defense. Let's put it out. But I can't say she's leaning for the prosecution. I mean, I think it comes off that way sometimes. If you remember in the Casey Anthony case, Belvin Perry, the judge, he looked like he was hated Jose Baez, right? And it may be because he might hate Jose Baez, because I was hating Jose Baez and I wasn't the judge on the case because he was. I mean, he would ask leading questions, objection, leading question again, and he did that from the beginning of the trial to the end of the trial, and the jury seemed to learn what a leading question was, but he never seemed to get it. So when you're a judge, excuse me, when you're a judge, that gets to you. I mean, you get, and plus, I thought in that case he was way over his head. It was a death penalty case, and this woman's life was on the line. And I mean, you have to worry about, and I don't know that he did this at all. I'm just saying, you as a judge, you worry. Is this person taking the case for the publicity when they don't have the ability to try a case of this magnitude?
Right, yeah.
And could this person end up in the death chamber
because this guy just he doesn't know what he's doing?
So I could see why Belvin Perry was angry with him. And people would say, oh, well, he rules more for the prosecution than the defense. Well, yeah, that's because the defense is wrong all the time because he doesn't seem to know what he's doing, you know? Every time you ask a question, you're leading. Every time the prosecution says objection, the judge is going to say sustained. And there's no, oh, wait a minute, I ruled 5 times for the prosecution, so I got to rule 5 times for the defense. That's not, if the defense is wrong, they're wrong.
Way, right?
You know?
It's not like,
so I could see where sometimes the perception is, oh, this judge always rules for the prosecution, so therefore she hates the defense. In this case, it does seem a little personal, and I think it might be maybe because he started with that stupid knock-knock joke.
Oh,
and then they had that picture circulating with his daughter and him eating ice cream and said that beats stupid. Although it was publicized after the Rachel Jean Tell testimony.
Right.
My understanding was I read that it had actually been posted
before
after the opening statements.
Right.
The fact that his daughter would do that, like, how dumb are you?
Well, you're 20-something, and
I saw one of your tweets where it was there was some kind of little altercation going on in the court, and you're like, control your courtroom.
Oh, I was furious.
Like, control, because there were a lot of instances back and forth. What kind of job do you think?
It was Dr. Bowles' testimony.
Yes.
She would not,
my God.
That witness needed, she needed to, what I would have done was I would have excused the jury very politely.
Okay.
And then I would have read him the right. I would have ripped into him and said, this is not your courtroom, this is my courtroom, you answer the question that's asked. And then, progressively, I would have done it in front of the jury. I mean, I would have done it in private because I don't want to, I don't want the jury thinking I'm angry at this witness unless I really need to send that message. So I would do it outside the presence. If he continued to do that, I'd start admonishing him in front of the jury.
Have you ever said,
answer the question. I don't want to hear another word other than yes or no. And then but I would have done the same to the lawyers. I mean, the lawyers were, though I said control your courtroom, I meant everybody. This witness was a train wreck. I mean, he was a train wreck.
Oh, man, was he bad.
For example, Don West, he would, he'd ask the question, and this witness would not answer the question, but turn to what looked like his manifesto that he wanted to read to the jury, and he'd
didn't want anyone else reading.
Right. My notes, you can't have them. So he would turn to that and start going off on a tangent. What Don West should have done then is not interrupt with another question, because that then led the prosecutor to get up and say, Judge, he's not letting him answer the question.
Right.
And you have this free-for-all. What Don West should have done is, objection, Your Honor, non-responsive. And that's when she should then rule, you need to answer the question. If the prosecution wants to get that out, they will ask you that question. You need to answer the questions that's asked.
It seems very difficult at times for a lawyer to keep his composure, because there's things going on where, as a human being, it looks like they literally want to punch people in the face. And
it's very high tension. I've had lawyers punch each other in the face.
You've had lawyers punch each other.
I've had lawyers go into the jury room and punch each other in the face.
Duke it out.
Yeah.
Hey, I want to ask, would you have liked to seen George Zimmerman testify?
Yeah, I mean, who wouldn't? What are you going to say next?
Right.
I mean, you've given this version, this version, this version.
Right.
Now, granted, the inconsistencies I don't think were significant. I mean, people do, people do change their testimony a little bit because, number one, they fill in blanks in their head. And number two, they want to make themselves look better. They may not have done anything illegal, but like I said about the sign, even if he didn't think he did anything illegal, he might be going, gee, I wonder if I was supposed to do that. No, I went out to look for a sign.
Yeah,
well, that's lying.
Better.
Right.
And of course, the jury then
the
prosecution's entitled to say to the jury, look, if he lied about that, he could have lied about everything else.
Right.
The problem is that's great if you're the defense, because that could raise a reasonable doubt.
Right.
But that's not the prosecution's burden. The prosecution's burden is to prove it beyond all reasonable doubt. It's like yesterday when he was talking to the doctor, and he said, Doctor, you don't know who threw the first punch, do you? And the doctor said, no. And I thought, neither do you.
Yeah.
You're the prosecutor. You're the one that has to convince me beyond every reasonable doubt. You don't have a single witness that says anything other than what George Zimmerman says.
Right.
So where is this case going?
Right.
You know, I think the case is going to an acquittal because not because George was right, or not because you know it's not a big deal that Trayvon was murdered or shot or whatever it was that happened, but because the prosecution doesn't have the evidence to disprove self-defense. They've got evidence to raise doubt, which is usually what the defense does, but they don't have evidence to disprove it.
That's if the jury's paying attention, though.
Well, yeah.
If they get their human emotion involved, and you never know what the hell
like I
is
said,
going to happen.
when I say I think it's going towards an acquittal, I'm just, you know, this is an odds. It's not a prediction much, but it's like, okay, I've seen cases like this, and this is where it tends to go.
Right.
The jury could very well look at it and say, you know what? You didn't have to shoot this boy. You did not have to shoot this boy, and say this is not self-defense, and it becomes manslaughter.
When you read the law, though, that you have to weigh with the evidence, it seems as a juror you can't just say, I don't like the fact that he did this, and throw away everything that really adds up mathematically.
In a perfect world, but
that's true.
That could happen.
Well, I understand it could happen.
That exact thing could happen.
Well, remember that there is a component there that the law does not. You know, it's not like it says. You know, as for second-degree murder, I agree with you. If the elements aren't satisfied, they can't make up elements.
Right.
Okay. As for manslaughter is just a killing that's not justifiable, and it is exclusively within the province of the jury to decide whether or not this was justifiable. They're the ones who decide, was George Zimmerman in fear for his life or serious bodily injury, and was it reasonable under the circumstances that he have that fear? Like you shooting the neighbor through the window, the neighbor's kid through the window. Okay, were you in fear, and was it reasonable under those circumstances for you to have that fear? If they say no, it wasn't. You know, we don't think that it was reasonable for him to fear serious bodily injury or death. They can say it's not self-defense, and it becomes manslaughter.
Yeah.
And then it's a question of whether there's enough there for the appellate court to say no, under those circumstances. By law, that would be self-defense.
And does a jury, because like a lot of times you said I think the defense in the case Anthony will throw out these leading questions, which a lot of times you want the jury to hear something, even though you know you're going to lose on the objection. Does the jury have to explain why they came to the conclusion? Like if you put something in the jury's head, like again with a leading question, and you know that they've heard that,
they don't have to explain.
So basically, that really can be a smart tactic by disregard that testimony. They'll never have to come back and say we didn't disregard.
Look at what Jose Baez did in the Casey Anthony case. He got up there and alleged that George Anthony had sexually abused his daughter since she was 8 years old. Not a shred of evidence of it. It never came into trial in any way, shape, or form. There was nothing to indicate. There was no evidence that her behavior changed at school, that she told any friends that her dad was molesting her over her whole life. Not one witness was called to testify to that, and of course Casey didn't testify. Now, why can he do that? Well, there are several reasons. One, she told him that, and she might be testifying, and therefore I'm going to put out there what the evidence is going to show, but hey, guess what? My client can change her mind about testifying, and I can't control that. If she decides she doesn't want to testify, she doesn't testify. You're going to tell the jury to disregard statements that were made in opening because the lawyers are not witnesses? Yeah, but you put that out in front of the jury, and now the jury is thinking, oh, wow, he molested his daughter. Okay. Yeah. Or she never said that, and that was fabricated for opening statement, and there's no way to prove it because you can always say, my client told me that, and she was going to testify, but she didn't testify.
Yeah.
So it's unethical if that's the reason. I have no reason to believe that Jose Baez made that up. I'm just saying that once that's out there,
it's out there.
It's out there, and that can motivate a jury to say, we think George was involved in some way, shape, or form, or something like that. So jurors just come back with a guilty or not guilty verdict. Sometimes they specify things like, if there's a requirement that they make a specific finding of something, they specify by checking a box. But it's really, you're prohibited from going into the deliberations of the jurors, their thoughts and their decisions.
Their notes are not, their notes don't.
In fact, the notes are destroyed after the trial. They're not even kept.
Well, off the subject, one quick question. I don't even want you don't have to go into it all. I'm just curious as to what you think. There's been so much speculation about the West Memphis 3 and I just want to know: do you think that those guys were railroaded, or do you think that the Alford plea?
Remind me the West Memphis three, because I don't know them all by catch names.
They went to jail for killing kids in the South, and they confessed to. One of them confessed to it, but
I remember reading about it, but I just didn't.
Okay.
I didn't get into it very much. But,
okay, I was just curious to what you thought.
You should watch the documentaries. It's amazing.
Really?
Yeah, I think that they didn't do it,
You
but
would
then people
enjoy
would
it.
email me going, "What do you?" It's like it's just a very interesting case.
I mean, the problem is that, I mean, I don't put a lot of weight in documentaries, because anybody can make a movie that paints anything any way they want. If they want to make it look a certain way, I mean,
add a little music, add a little grainy over the footage,
and you can make that movie Monster about Warnos, who was a serial killer in Florida who's killing men on you can paint a serial killer to look like a poor victim. Just a serial killer.
Yeah.
It just depends on what Hollywood or whoever's making the movie wants. And movies. And by the way, if you make a documentary that is consistent with the way the case went, it doesn't always do as well. It's when you make it controversial, like, oh my God, these people were railroaded.
A little drama.
That it sells. Right. Now, it may be that it's true. It may be that the documentary is completely accurate and they were railroaded, but I don't know.
Do you the Supreme Court is really interesting to me, because do you find it irritating that you can almost predict on a court of that magnitude, how do you always know how Scalia is going to go, or how do you always know how Ginsburg is going to go? How does this happen? I think Kennedy is the one that kind of goes back and forth. Why are these so predictable down the line?
Well, because the courts operate under a principle of stare decisis, which is precedential law. The cases that came before govern what you do in the future, and we already know from prior cases how these justices view certain issues, whether they respect privacy rights and see them as a justification for Roe v. Wade, or whether they feel that was a right that was manufactured and created by the Supreme Court to reach a result they wanted to reach. Or we know their opinions. So when an issue comes up, we know that if this opinion involves a privacy right, we know that Scalia is going to say this, and we know that Kennedy's going to say that. I mean, within framework, we know. So it becomes, people who follow the Supreme Court are very good at predicting what they think it's going to be, an 8-to-1 split or what. Now, that's not always accurate, but like the Affordable Care Act, the Obamacare. Excuse me. That was, as written, that was completely unconstitutional. It was done under the Commerce Clause. The Commerce Clause had never, ever been used to force private citizens to buy anything. It was basically to regulate things you bought, and it's a very broad power, no question about it. It's been used for a lot of things, but never in the history of this country has the Commerce Clause been used to force you to go out and buy something you didn't want to buy. No question, it was going to be unconstitutional. And then one of the
tax.
And then one of our justices went out and said, you know what? This was really a tax. Now, mind you, everybody had said it was not a tax, including the legislators who wrote it.
Oh, yeah.
The president of the United States said this is not a tax. There was taxing language in it that they took out to make sure it wasn't viewed as a tax. And there's a dispute about whether that was done because to reinstate faith in the courts, see they don't always go along party lines, or because the justice wanted to have a particular outcome, and this was, in other words, it's a good act because you get, people have pre-existing conditions, and no question, pre-existing conditions are a big problem for people.
Sure, yeah.
And my family is full of issues. I mean, everybody in our family is warranties expired, and we're broken everywhere. So I really appreciate the pre-existing condition coverage and the fact that my kids can stay on my insurance till 25, and all those things, good things. But that wasn't the question. The question was it legal?
What justice, by the way, said it was a tax?
I'm trying to remember if it was Roberts or Kennedy. I don't remember which one.
Isn't Kennedy one that was appointed by a conservative judge but tends to go liberal? Or he's the one that's all over the place,
you can't always count on, and this is the thing, is also that the court used to be very apolitical. You could count on them to do whatever was constitutional, regardless of the political slant or their political feelings. And over the years, that's changed and changed and changed to now where you expect their rulings more to be political, which is why people are losing a lot of faith in the court. But Sandra Day O'Connor She was appointed by Reagan. She was supposed to be a staunch conservative and turned out to be as middle of the road and sometimes more liberal than others on the court.
Wasn't Stephen Breyer a big disappointment to whoever appointed him? Because didn't he always go the opposite way of how they thought he was going to go, and he wound up lining up completely?
They all disappoint me, actually.
who appointed him? Do you remember?
No.
Okay.
No.
I don't know why I'm asking specific questions.
Yeah, I guess the trial is in session now. What are they?
Well,
I think she's going to judge. Or,
it's about to be in session.
Turn the lights on, Jesus.
She's going to decide whether, I guess, that animation gets admitted.
She's got a couple of decisions to make. One is the animation is going to be admitted. The other's going to
phone evidence.
The other is the phone evidence, and then I think there's a hearing about
a witness. I guess it was.
It was Donnelly, the war vet,
the Vietnam guy that said that he had identified Zimmerman's voice. Sure. I guess. They're saying his sequestration
testimony. Apparently, he was in the courtroom. He shouldn't be in the courtroom.
He heard
the rule of sequestration says witnesses can't be in the courtroom. If one side or another invokes it, the witnesses who are going to testify have to be outside the courtroom. They can't discuss their testimony. They can't be in there. And he apparently was. I guess she's going to have a hearing, find out why he was in there, what he heard, and she'll decide what to do about it.
Right.
Well, didn't this struck me?
By the way, the lights were off last night. That was last night. Last night.
This struck me as odd yesterday listening to this pathologist testify because he referenced, I think, what the medical examiner had said. And I'm like, I guess, is that just from reading the report, or did he hear the testimony? Because I was like, why is he...
Well, first of all, experts can be in the courtroom.
Oh. Okay.
Yeah, experts are excluded from that because they base their opinion on what other people say. That the experts are allowed to say, based upon my review of this and the testimony of this officer and this, my opinion would be whatever. I mean, that's the only difference really between experts and lay witnesses is lay witnesses can't give opinion. Experts can give opinion. So... Lay witnesses have to basically just state the facts.
I just want to call Alex all day and just ask him questions. And what do you think about?
Unfortunately, we have to move on, and I'm sure that Alex wants to start tweeting. No, you got other shows to do. I'm sure you're all over the place. It's amazing.
Yeah, I've been commenting a lot on this case.
Seen you popping up. Do you see the media as being biased in this or holding back from certain things?
Well, I mean, at the outset, I don't know if you remember, but last year, a major network. I mean, remember there was a lot of criticism of the fact that they would show George Zimmerman's booking photo and then a picture of Trayvon from when he was 12 in his jersey. And I understand that you get whatever pictures you get from the family. If the family gave you a picture of him in a jersey, they're going to run with it. When he was 12 years old, I tend to believe they must have had some pictures of him since after he was 12 years old. But but they ran with that, and they kept running with it and kept running with it until they got so much criticism. But they still air it. But there was one network.
NBC edited the tape.
I wasn't going to say who it was, but
they should be crucified for that.
They took the tape, the 911 tape that said where George Zimmerman said. There's this guy. He's suspicious. He's walking between houses. I think it looks like he might be on drugs. And he's looking. It looks like he might be looking into houses. And that was in response to the dispatcher who said, when he said, "I'm looking at the suspicious character." She said, "What's suspicious about him?" Well, he's walking between houses and all this stuff. And then she said, "Is he white or black?" And he said, "He's black." So they edited it to say, "I'm looking at the suspicious guy. What's suspicious about him? He's black."
He's black, yeah.
And I mean,
Jesus.
I am not. I mean, that really is despicable.
Yeah.
Because I don't doubt that was a big catalyst for a lot of the racial animus that started like a fire. I mean, why would you do that? Why, as a news network, would you do that? Now,
what's the motivation?
Because they're agenda driven. It really is reprehensible and unspoken. Like they've never sat down in a room and said, "This is our agenda."
Right.
But they all kind of know it. It's like I don't know how they know it, but it's they just understand that this is the narrative.
Well, they did. They said that it was some intern or something. I have trouble believing that a major network lets an intern edit tapes to put on the air. I don't remember this.
Anybody.
Did they give his name?
I'm sure. I don't know if they did at the time.
They protect. It's funny. They don't give their own.
Yeah.
But
so I don't know. I don't know why that. I don't know why you would do that. I mean, how would you think you would actually get away with that? Everybody else has the tape.
Yeah.
So I mean, that kind of weighs in their favor that this was some loose cannon at our network. But why does a loose cannon at your network think that they can do that at your network?
Yeah.
That's just crazy.
I'm also seeing, like last night when this was going on with trying to decide about letting the phone in and the contents of Trayvon's phone. all of a sudden the cable news networks weren't talking about that. They weren't mentioning what was on the phone. Everything else that the judge had to decide on, outside of the eyes and ears of the jury, they would still talk about. And that dead silence, it's like it doesn't fit their storyline. They want it to be a white male shot, a white male cop wannabe shot this black innocent teen, and that's what they want.
Well, I'll say this: I don't trust any media. Mm-hmm. I watch CNN. I watch Fox News.
Right.
I take them both with a grain of salt. I look at both of them so that I can make up my own mind. Mm-hmm. You know, there are people who are just like, I'm not watching anybody but this one, and the other one is the enemy and all that. But I take it as you don't know what you're getting. If you want to read a book that'll put it in perspective, read the book Bias by Bernie Goldberg. Mm-hmm. And Bernie, it's funny, I laugh because I've read probably every one of Bernie's books because I like Bias so much. It's kind of like taking that, you remember the movie Matrix where he says you can take the blue pill or the red pill.
Right, yeah.
If you take the blue pill, you go back to the way things were and you won't know anything. If you take the red pill, you will never be the same again. You will never look at things the same again. You read the book. It's like you took the red pill. You never watch news stories the same. You see the subtle things. You see the subtle things that you go, wait a minute, that jumps out at me. Like, for example, when Hillary was running for the Democratic ticket, she was the media darling. They loved her, and so she could do no wrong. But when Obama came along, he became the media darling. Uh-huh. And then you start to see a noticeable change in the way that she was portrayed.
Presented her.
Some, and I wouldn't say all, I certainly don't look at them all, but in some, it started jumping out at me that you would see a picture of Obama, and it was very presidential, and he was standing there and gazing into the distance, like in his poster. It's a beautiful picture. Right. and then they would put, they would be talking about a debate between Hillary and Obama, and they would put that picture for Obama, and the one for Hillary would be her mid-sentence with her mouth open.
Her mouth is always open, twisted, crooked, her eyes half shut.
And they never did that before.
Yeah.
But you start to suspect, are these subtle messages kind of like, he's better than her, because they've made up their mind who they want to back.
Wow,
I don't know that that's true, but when you read the book Bias, he talks about what goes on in the media behind closed doors and things like this. And then he wrote another book, Arrogance. And the funny thing about Bernie Goldberg is, you see him all the time now on O'Reilly, on Fox. He was a liberal journalist, and he even says in his book, he says, look, and I totally get this. He says journalists are by definition liberal because our job is to challenge authority. We challenge the government. We have to be the liberal. We have that slant naturally, but we're not supposed to let it go into our writings. Yeah. We're supposed to be neutral, not give our view of the world. And I laugh because as I've read his books, Bias, Arrogance, and the ones that followed, I see this progression where he went from being a liberal journalist to now, I don't know if he is still viewed as liberal, but, he's on O'Reilly, on Fox.
Right,
all the time, commenting basically about why the liberal reported this, why the media reported these stories in this fashion instead of that fashion. And he's a very credible guy. But, maybe he's on Fox because that's the only network that'll put him on. I don't know.
You wonder, was there, because they don't do racial descriptions anymore a lot of times in these things. And again, if the guy is caught, it doesn't matter. But if like I've read things on the Daily News, they were looking for a rape suspect. They said he was wearing a red hoodie. Like, they don't give you the suspects just like that would just kind of cut the hunt down from white to black. That eliminates a lot of suspects.
I totally disagree with that.
Did they send out that mandate? Is there a memo that says cut this? How do they all know to do it?
There are viewpoints among some of the media who say that they do not want to publicize that it is a black male or Hispanic male because they feel like they are sending a message that all black males or all Hispanic males are committing crimes.
So the news is not important. The truth is not important.
I think it's worse than that because you need a description of an individual in order to. You would never say like, well, I don't want to say it was the person who raped her has a hair lip because then we're saying that all people are hair.
Start laughing.
You really need to you need a description to know who you're looking. If you're not gonna give a description, then don't give a description.
If you listen to a police scanner, the first thing they put is race. of the person.
Because you want to catch the person.
Right.
So the cops need to know, am I looking for a white male, Hispanic male, black male? It's not maligning to the extent that they feel that they are putting out descriptions for black males too much. It's because, well, guess who our ghettos are filled with?
Right.
Okay, who do you think is going to commit violent crime? If you filled all the ghettos in America with white people, the only thing that you would hear on the news is this white person did this, this white person did that. Because when you live in a situation where you don't have hope of getting out, people become desperate. So you're going to naturally, statistically, have more crimes by the people who are more desperate.
But the news isn't going to sit there and go, well, people, here's another black guy that did that. They're just reporting what happened and trying to put out a description of somebody if they need to. But, I don't see it as something that's a bad thing. I mean, it's part of the story.
They're really reprehensible. And what's the guy's name, Bernie Goldberg?
Yes.
What a terrible because they become so hateable. Like, and I don't know when it changed.
Bernie wrote a book, Biased, that outs that.
Yeah,
he wrote a book that says this is what the media does, and as a result, he actually wrote it because he tells you in the book that he was noticing his colleagues constantly giving stories with a slant.
Yeah,
subtle things like. Dan Rather would have a panel, two people, two talking heads, and one he would identify as a so-and-so, the member of this conservative think tank, to let the audience know this is the conservative viewpoint. And then the woman that was on the other side of he would just say, a learned law professor. This is the conservative think tank person. This one is a learned law professor. So he said he would see things like this, and it really bugged him, and he thought, even if that's your perception, you're supposed to, as a journalist, report it neutral, not from your viewpoint. And so he finally, one day, the straw broke the camel's back was he wrote, he saw this piece and he said, I've got to write about this. So he wrote a piece about liberal bias in the media from a journalist viewpoint, saying, guys, and his viewpoint was, I don't think we do it intentionally. I don't think we're purposely slanting it. I think that this is the way we see the world, so we think everybody sees it this way, and we need to be careful. So it's a pretty tame piece. But he knew the New York Times was not going to publish that. So in his mind, he said, there's no way. He says in the book, and I don't know how true it is because that's not my world, but he says, you want to know how ABC, CBS, and NBC report the news? Every morning they open up the New York Times and see what they reported. And he said that's true. He said they follow whatever's in the New York Times, and that's how they report it. So he said, I did not believe for a second the New York Times was going to report my piece. So he made the cardinal sin of giving his paper to the Wall Street Journal, and they published it. And he said they weren't angry at him about the piece he wrote. They were angry that he gave it to the Wall Street Journal. And he says in the book that he was blackballed. They wouldn't talk to him. They wouldn't hire him. They wouldn't send him any work. And they basically sent him off to shrivel up and die.
Jeez.
And so he said, you know what? I'm going to write a book about it.
And he's been crucifying them ever since.
Probably.
Good for him.
Yeah.
Get him on. I'd love to talk to him and hug him.
He's in Miami, and his name is Bernie Goldberg. And the book Bias is worth reading. And not I don't say it because you should distrust ABC, CBS, NBC.
Right.
I look at everybody that way. I look at Fox and CBS, ABC, and NBC as they have an agenda. They may have an agenda, let's say, and I don't necessarily want to fall into that agenda. I want to make up my own mind, and I think that. Nowadays, when people say, like, why doesn't anybody trust the media anymore? I think that's why. I think people aren't that stupid. I think people see and pick up on slants. Whether they think that Fox News is extreme right or they think that NBC is extreme left or whatever, people pick up on slants and they want to make up their own mind. And that's why I think circulation for newspapers and stuff like that is all down.
Well, I definitely would like to talk to you again, maybe after the trial or when they're deliberating or something. But very insightful, man. Thank you for coming on. Judge Alex.
You're
great. Look for the show, Judge Alex. I guess check your local listings, as they say. It's very entertaining,
Thank you
man.
very much. And you can follow me on @Judge Alex Ferrer.
Yeah.
Ferrer.
Ferrer.
And next time you come back, I have a girl I took out who kind of indicated sex and then didn't give any, and I'd like to know what I could do about that legally.
Well, that's a clear breach of contract. But she may have the defense that it's justifiable.
Exactly.
So.
All of a sudden, she got her eyesight back.
After the break, the interns and their book report.
Yes, their book report. Isn't that
Quincy.
Great?
What a weird show we do. Judge Alex, thank you, man. This was a pleasure.
Pleasure's mine, guys. Thanks a lot.
The Opie and Anthony Show continues in moments.